110th session in the Continuing Legal Education Seminar Series of the Bar Council of Kerala, conducted by its Seminar Committee. Today we are privileged to have Brigadier A. Manoj with us to speak on the topic Army Act and Court Martial. Brigadier Manoj was a student of Government Law College, Calicut from 86 to 91 and then did his LLM. He is the only Judge Advocate General, JAG, who has done 2 stints in the field of with the UN in DR Congo once, and then afterwards at the UN headquarters in New York. I have put his biodata in the chat box. Please go through. He is an acknowledged expert in the field of military law. And is a serving officer of the legal department of the Indian Army. So without further ado, let us go into his talk. I welcome Brigadier A.R. Manoj. I welcome all the members participating in the session. I also welcome with us, from the bottom of my heart, the Bar Council members who are present here today. Welcome all. Manoj, Brigadier Manoj, I hope we can start now.
Thank you so very much, Girish. I hope I'm audible to every one of you. Great. It's a pleasure, privilege, honor to be part of this session, especially organized by my friend from Government Law College, Calicut, of which I am a proud alumni. And in the next about half an hour or so, maybe less than that, I'll try to apprise you about the nuances, or at least an introduction to the military law. As we say in our terms, it is Army Act, because military as such constitutes the armed forces of the Union, constitutes of all 3 forces, that is the Army, Navy, and Air Force. So Army Act is my forte, since I am from the JAG department, that is the Judge Advocate General's Department of the Indian Army. This department is responsible for maintaining the discipline, or at least the legal aspect of the Indian Army. As you all know, we are under the Constitution of India, and as far as Constitution goes, rule of law. Rule of law is the prime consideration for anything, any activity, any sphere of activity in our country. And so is the case with Indian Army also, because Indian Army also is subject to rule of law. We have a very good system, unlike the notions outside that it's just Army means court martials and other things and shooting down people. No, that's not it. We are a very professionally, legally abiding, rule of law following army. With that in mind, I'll just take you through the nuances, or at least the introduction of the army. Let's start with the origin of Army Act, or the military law per se in India. It all started, as you know, the army started from advent of the present system, advent of the or incoming of the East India Company. And as such, what is today the Indian Army, or the army setup, originated from a very small group of guards who were supposed to guard the factories of the East India Company. In the 17th century, these guards were introduced, and over a period of time, by 1754, they had to come out with an act, because the guards or the army expanded to such an extent that the acts of mutiny, desertion, etc. started. You must be aware of these terms: mutiny, desertion, etc. So this necessitated the introduction of the Mutiny Act of 1754. So the first kind of legislation or codification of law started from 1754 under British East India Company. Thereafter, over a period of time, as you all know, Government of India Act 1833. As per the Government of India Act, articles of war, for the first time a codified sort of military law, was set up by the Articles of War of 1845. The Articles of War, as the army started expanding, the requirements, the problems to deal with, to maintain discipline, etc., expanded. So that resulted in lots of amendments. And the main amendment after 1845 came in 1895. Thereafter, again, this was felt to be very less as far as the maintenance of discipline was concerned. So the Government of India Act again, they sat together and legislated something called the Indian Army Act of 1911. So I would say Indian Army Act of 1911 as the main precursor to the present Army Act. After 1911 codification, as you all know, the two world wars took place. Thereafter, the struggle for independence. And after independence, it was felt that as per the requirements of the forces of the Indians, and since the Indian Army constituted mainly of Indians, we had a different requirement, as also considering the lessons we learned from the two world wars in which we participated. So that led into the passing of the Army Act 1950. You must be aware that we have certain special provisions in the Constitution itself, which was necessitated by the requirements of the functioning of the armed forces, which as such is in a special category. Army Act, as you know, is a special act as well. If you go to the CRPC, Section 5 of the CRPC says something called a saving clause, as per which the special laws for the special laws, the provisions of CRPC are not applicable. So Army Act is a special act. 1950, we codified this act, and the Constitution itself caters for certain abrogations or certain restrictions, I would say, restrictions to the fundamental rights. Part 3 of the Constitution speaks of fundamental rights, and Article 33 of the Constitution says that the fundamental rights part of this Constitution could be restricted to the persons belonging to the armed forces. That is Article 33. Some of the examples of those restrictions are your freedom of speech. As far as like what I am addressing as of now, I had to take a special permission from the headquarters of mine to address you all. I have to give this script. But this being something which is in the public domain, it was not much of a problem. Otherwise, as you all know, we have so much of confidential matters in our hands, which we are barred from sharing. So that's why these fundamental rights are very much part of the requirement of the armed forces, and that's what was recognized by the Constitution. As also, you know, we have a special setup when it comes to adjudication or judicial system. We have something called courts-martial, which is a special court. So to uphold the functioning and the making smooth the functioning of the courts-martial and to ensure less interference therewith in consonance with the requirement of the discipline, the Constitution itself has taken away courts-martial from the purview of judicial superintendence by the High Court. This is vide Article 227, Clause 4, that the courts constituted on the armed forces of the Union are beyond the purview of superintendence by the High Court. Similarly, the provisions of special leave petitions, Article 136, vide Clause 2 thereof, again, the Supreme Court has barred from entertaining any adjudications by the courts constituted under the law of armed forces of the Union. So these three provisions, just for your information, this is how the requirements of army was recognized specially, and a special status was given to the military forces, that is Army, Navy, and Air Force. With that, I will now enter into the Army Act per se. Okay, as I told earlier, Army Act is a special law catering for the requirements of maintenance of discipline in the Indian Army, because that is a requirement. So as happens with any other laws of the country, it's a very well laid down act, starting with the introductory clauses, which include who all are subject to the Army Act. Thereafter, definitions. That is, the terms used in the army are well defined in the initial portions itself, definition clause, as you find in IPC, CRPC, everywhere. So next is definitions. After definitions, we move on to the how you enter into the army. How you enter into the army is maybe by way of commission by the president in case of officers, by way of enrollment in case of Jawans or other soldiers, I would say. After entry into the army, you have to have what are the conditions governing you in the service of the army. That is the next chapter of the Army Act, which deals with conditions of service. Conditions of service include while in the army, you are to maintain certain standards. Thereafter, how your services could be terminated. Termination may be by way of a penalty also. It may be in a normal course also, like release after you attain the age of superannuation, etc. That's called discharge. So you, on one side, you have dismissal. That is, if you engage in activities which are against the interest of the union, you could be dismissed from service by administrative action itself. That is without going through a court martial. Because in such cases, you may say that, especially in cases of espionage, etc., you could say that it's called the presidential pleasure also. You could say that this the act is of such a nature that it should not be subject to a public trial. It's of secret nature. So in such cases, you could chuck out the individual out of the army by way of an administrative action. Of course, after again following the rule of law, that is giving him a show cause notice, telling him what are the acts of which he has been found blameworthy, and his reply is taken. Thereafter, it is processed through the channel up to the cabinet, that is Ministry of Defense, and President's assent is ultimately accorded for this severe action. Otherwise, the system is to follow the judicial process, wherein we go in for disciplinary action by way of court martial. So the conditions of service govern the special, considering the special nature of the interest of the service, the conditions of service are laid down in Chapter 4 of the Army Act, which also includes this restrictions of fundamental rights. That is, not be part of a trade union, etc., not freely speak to the press when it comes to matters of the army, etc. These small restrictions on fundamental rights is of course there. After conditions of service, there are certain service privileges also that the Indian Army is exempt from maybe paying toll tax as you cross through the various tolls. You would have seen people flashing the identity card and not paying the toll tax or toll which is taken from other citizens. That is a privilege given under the Army Act itself, as also Indian Toll Tax Act. This is one of the privileges. Other privileges are like, as you would be knowing, or I'll just apprise to you that when an army person has any land dispute or any civil dispute, wherein he is either the plaintiff or the defendant, there is a provision in the Army Act itself which says that if he is sent on leave for say 1 month, the commanding officer of the individual certifies over there that this individual is being sent on leave for finalization of this case. And the magistrate is supposed to take cognizance of that, in the sense that he's supposed to dispose of that case within that period of 1 month leave which is granted. This is a special privilege given to a soldier. But I agree, practically it is very difficult. So invariably what happens is, though he may entertain it initially, but then it goes on. At least we have this provision, which is a special privilege extended only to the persons of the armed forces of the Union under the Army Act. So these are some examples which I just gave you. There is immunity from arrest, but people usually consider that army persons cannot be arrested at all. No, the immunity from arrest is only with regard to civil disputes wherein some damages, etc., or such nature of orders, not for any criminal offense. There is no immunity whatsoever from arrest for any criminal offense. A soldier is as much subject to the law of the land as any other citizen of India. Only exemption is if he conducts such a crime in pursuance of his performance of duties. For example, he is deployed in a counterinsurgency operation where, while maybe using force against the enemies, in the crossfire some civilians also get killed. In such cases, it is treated as during performance of his official duties. In such cases, arrest can be made only after sanction of the central government, that is Ministry of Defense. This is also part of our own CRPC, Section 45, immunity against arrest. We also have Section 197, Clause 2, wherein there is the magistrate is debarred from taking cognizance on offences of such nature unless there is a sanction by the central government. So these are also part of these civil privileges. Thereafter, you enter into the main thing, that is coming into the realm of court martials or any disciplinary action. You have to be found blameworthy for some offences. So where are the offenses laid down? The offenses are laid down under Chapter 6 of the Army Act. It starts with section 34 to 69. Mostly it is offenses like which are specific to the army. For example, acts during operations against the enemy, acts like mutiny, desertion, using criminal force to a superior officer. Also acts like, for example, absence without leave, which in civil is considered very minor, but no, in the army, it is not considered that minor, and people get dismissed from service or even imprisoned for absence without leave, though not for short periods, but if it is prolonged or if it is a deliberate absence to avoid military duties. For example, if there is an operation going on, you just run away from the place to avoid that. These things are always viewed very serious. So these are some of the offenses which is specific to the army. Most of the offenses are punishable by up to 7 years of imprisonment. But serious offenses like mutiny, desertion while on active service or when called for active service, etc., are punished more severely, including death sentence also. But it's very rare that death sentence is awarded. That is one thing which we have to take note of. After offenses comes the punishment. So punishments, as I just told you, ranges from death up to a warning, or in our terms, it's called severe reprimand or reprimand. So these are the punishments that could be awarded depending on the offense for which he has been convicted. After punishment, okay, we have to have a procedure how to deal with these offenses. Those procedures are laid down under the next chapter, that is chapter 8 and 9, which deals with arrest and pre-trial issues. So arrest is also prescribed as to, we have when a person is arrested, we take him into custody in military prisons. It's not military prison, military custody we call it. We have something called a quarter guard. So these persons who are found blameworthy are put into the quarter guard if required. It's not that it's mandatory that if a person is found blameworthy for something or tentatively charged, he has to be placed under arrest. No, it is just like any other offenses where CRPC applies. If it's serious in nature, then only we subject him to an arrest. Serious in nature or offenses which involve his chances of tampering with the evidence, causing damage to others, etc. These are the considerations. That is, firstly, the gravity of the offense and these two factors which I just mentioned to you. So this is as far as pre-trial procedures are concerned. Mind you, we have a very good system wherein I would say it is more accused friendly as compared to the system in the CRPC itself. Because in CRPC, after lodging of FIR during police investigations, we have this 161 statement by the police wherein the accused is not given any right. Whereas when it comes to Army Act, Army rules, the Army rule requires that there are 3 stages wherein an accused gets chances, that is compliance of natural justice, audi altum partem, wherein he gets a chance to put up his case or cross-examine witnesses. First is if there is an investigation by way of a court of inquiry. So during court of inquiry, if a person is about to be found blameworthy or his involvement is prima facie revealed, then he has a right to cross-examine each witness that is part of that court of inquiry. And he also has the opportunity to put up his own defense, including produce defense witnesses to show that he is not at all blameworthy. So all these rights are given at the court of inquiry stage, firstly, if there is a court of inquiry. Secondly, the disciplinary proceedings start with the hearing of charge, what we call a hearing of charge. That is, as in the CRPC, there is a FIR lodged for certain offenses. We have a investigation wherein the person is given a tentative charge that he is blameworthy of one of the sections under 34 to 69, which I just mentioned. And the commanding officer of the accused calls him, he hears the charge, he doesn't ask him guilty or not, he just reads out their charge and asks him, do you want to give your version that you are not involved in that act, or such like rights are extended to him. After that, the commanding officer, if he finds that no, this guy is blameworthy and the case should be proceeded with, Then there is further investigation by way of recording of a summary of evidence directed against this single person, accused person. You can equate it with the police investigations and filing of a challan to the magistrate. So after that summary of evidence is recorded, a draft charge sheet is made as in challan, or what you call the final investigation report. So based on that charge, the next procedure may be, if it's a minor offense, maybe a summary punishment or summary trial, as in CRPC also, for only minor offenses. The maximum punishment here would be 28 days military custody, and he is retained in service. His services are not affected. And it could extend to, as I told you earlier, also reprimand or severe reprimand. That is just a warning. And if the offenses are a little bit more serious, then we have 3 forums of court martial. First is the lowest forum called summary court martial, wherein the sole judge is the commanding officer. He has powers to try only up to a non-commissioned officer. That is, in our parlance, we could call it Jawan or constable, as you compare it with the police maybe. So for them, summary court martial by the commanding officer, wherein the maximum punishment that could be awarded by the commanding officer is imprisonment for 1 year and dismissal from service and lower. But for a summary court martial to take place, all pre-trial procedures, including the summary of evidence, etc., should be recorded, and the accused is given copy of the charge sheet as also whatever is against him at least 96 hours before his trial, so that he has ample time to prepare his defense, put up his defense. During the summary court martial, he is also assisted by a friend of the accused. After summary court martial, the next serious form of court martial is district court martial. When it comes to district court martial or general court martial, these are the 2 serious ones, and summary general court martial, 3 of them. In such cases, it's the jury system that is followed. That is, at least if it's a district court martial, at least 3 senior officers are members of the jury. The court is guided by a person from my department, that is the judge advocate department, who acts as the judge advocate. The judge advocate ensures that the proceedings take place as per law, following the Army Act and Army rules, wherein laws of evidence, Indian Evidence Act, is also applicable. So all rights are ensured to the accused, and at the end of the prosecution case and the defense case, there is a summing up of the evidence that has come on record by the judge advocate. Based on that, the jury, that is, if it's district court martial, the jury consisting of 3 officers, or if it's a general court martial, the jury consisting of 5 officers. They sit in judgment based on the evidence that has come up, that has been summed up by the judge advocate. Mind you, in both, in all these 3 forums, that is district, general, and summary general court martial, the accused has the right to be assisted by a defense counsel. He can engage any lawyer of the country if he wants. And if it's a serious offense which is punishable by death, if the accused cannot engage a lawyer, the government itself provides him the services of a lawyer. So it is totally transparent. In fact, there was a comment by the Honorable Supreme Court in one of the cases titled A. Hussein versus Union of India, wherein they, after going through all the procedures of the court martial, the Honorable Supreme Court ruled that the system followed by a court martial, if not fairer, are at least equally fair to any system followed in the law of the land, that is by any criminal code of the land. So that is the stamp of the Supreme Court that has been accorded to the court martial system under the Indian Army. After these things, then the execution of sentence part follows. Just before that, even after the findings, or if the accused is found guilty, sentence awarded by a court martial, there is another filter. Any court martial proceedings, that is district court martial, summary general court martial, or the general court martial, which are constituted of jury members, is subject to confirmation by a superior authority. So that superior authority takes a decision whether the proceedings have been followed properly, and the decision arrived at is legal and proper. For that, they have the assistance of people from my department, that is the judge advocate department. So we have to prepare something called a report on trial. Based on that, the superior authority confirms, or if he finds any illegality, any problems, in the proceedings, he sends it back to the same court once for a process called revision, wherein the faults that have been pointed out are again reconsidered by the same jury. Thereafter, they can arrive either at a different sort of findings, or they can stick to their earlier findings, telling that no, we have considered all these things. So once revision is there, after one revision, if still the superior authority feels that the proceedings are not legally in order, it has only two options: either not to confirm or go by the second decision or the final decision of the court. So this is how the provision of confirmation and revision comes into play as far as Army Act is concerned. After revision, there are procedures of execution for sentences. The manner or procedures for execution of sentences ranging from death to down below. Obviously, earlier it was by death sentence, used to be by firing or by hanging to death, but nowadays that firing thing has been taken out. After execution of sentence, we also have a chapter dedicated to giving of pardons, remission, suspension, etc. of sentence. In between, the accused is also given the right to put up a pre-confirmation petition. That is, as I told you, after the finding of sentence, it goes for a confirmation to a superior authority. Between that stage, he has the right to address a petition to that authority which confirms. And after confirmation, if he is still aggrieved by the order, then he has another right to approach the higher authority, including the Chief of Army Staff. That is called the post-confirmation petition. So these are the whole lot of rights available to a person subject to the Army Act. With this, I'll just also touch upon what are the remedies outside the army available to a person subject to the Army Act. Fortunately, after introduction of Armed Forces Tribunal, there is one forum of appeal which can reappreciate the evidence based on which a person was convicted. Before this Armed Forces Tribunal came into act somewhere in 2009, the act is of 2007, there was no forum for a proper appeal. This was observed again by the Honorable Supreme Court in a landmark judgment called Prithpal Singh Bedi versus Union of India. This was a judgment of 1982, wherein the Supreme Court told that, see, in the army, you don't have a system where people can reappreciate evidence or the confidence that their court-martial, if not conducted properly, at least it is subject to a reappraisal by a judicial independent authority. That thing was not there. So this was observed by the Honorable Supreme Court, and they in fact urged the Ministry of Defense or the Government of India to come out with some forum so that these people subject to the Army Act have a redressal forum. It took so many years, and ultimately in 2007, the act was passed. Now we have different benches throughout the country to deal with the appeals against court-martial, that is called court-martial matters, as also any other service grievance, conditions of service, pension, pay, promotions, etc., for which against which the person subject to the Army Act is aggrieved, he can approach the Armed Forces Tribunal. Section 14 of the Armed Forces Tribunal deals with service matters, that is matters which are not within the purview of the court-martial, and Section 15 deals with appeals against court-martial. So this is the broad system of the Army Act and Army rules. And now, just to put an end to this monologue, I would be very keen to take on questions or any other points of doubt which my esteemed audience would have from me. Thank you. Any questions, please?
Someone had raised his hand. I'm sure questions start now.
Sir, revision provision and the
Okay. ഒരു കോർട്ട് മാർഷൽ കഴിഞ്ഞാൽ അക്യൂസ്ഡ് അഥവാ ഗിൽറ്റി ആവുകയാണെങ്കിൽ ഏതെങ്കിലും ചാർജ് അത് കഴിഞ്ഞ് സെന്റൻസും കിട്ടുന്നുണ്ടാവും ഗിൽറ്റി ആണെങ്കിൽ ഓബ്വിയസ് ഈവൻ നോട്ട് ഗിൽറ്റി ഈവൻ ഇഫ് ഈസ് നോട്ട് ഗിൽറ്റി സോ വാട്ട് എവർ ദി ഫൈൻഡിങ് ഈസ് ആ ഫൈൻഡിങ്ങിനെതിരെ ഒരു സുപ്പീരിയർ അതോറിറ്റിക്ക് ആ കോർട്ട് മാർഷൽ പ്രൊസീഡിങ്സ് പോകും. എങ്ങനെയാ അത് പോവുക? കോർട്ട് മാർഷൽ കഴിഞ്ഞ ഉടനെ ഐ എം ടെലിംഗ് ദി പ്രാക്ടിക്കൽ ആസ്പെക്ട്, ജഡ്ജ് അഡ്വക്കേറ്റ് ഇസ് റെസ്പോൺസിബിൾ ടു മെയിൻറ്റെയിൻ ദി പ്രൊസീഡിംഗ്. അപ്പൊ എല്ലാ പ്രൊസീഡിങ്സും ഈ എല്ലാവരുടെ എവിഡൻസും എല്ലാം ഉൾപ്പെടുത്തിക്കൊണ്ട് എക്സിബിറ്റ്സ്, വിറ്റ്നസസിന്റെ സ്റ്റേറ്റ്മെന്റ്സ് എല്ലാം ഉൾപ്പെടുത്തിക്കൊണ്ട് ഒരു കോർട്ട് മാർഷൽ പ്രൊസീഡിംഗ് ആണ്. ആ കോർട്ട് മാർഷൽ പ്രൊസീഡിംഗ് ജഡ്ജ് അഡ്വക്കേറ്റ് നേരെ എന്നെ മാതിരത്തെ ഒരു ഡിപ്പാർട്ട്മെന്റിലേക്ക് അയക്കും. ഇറ്റ് ഇസ് കോൾഡ് ദി ഓഫീസ് ഓഫ് DJAG. DJAG ഓഫീസിൽ ആ കോർട്ട് മാർഷൽ പ്രൊസീഡിങ്സ് മൊത്തം നോക്കിയിട്ട് അതിൽ ലീഗലി വല്ല പ്രശ്നം ഉണ്ടെങ്കിൽ, ഫോർ എക്സാമ്പിൾ യു ഹാവ് അഡ്മിറ്റഡ് ഇൻ എവിഡൻസ് വിച്ച് അതർവൈസ് ഇസ് നോട്ട് അഡ്മിറ്റഡ്, ഫോർ എക്സാമ്പിൾ, or while arriving at the finding there were material factors which had not been considered by the court properly. ആ സംഗതികൾ പോയിന്റ് ഔട്ട് ചെയ്തിട്ട്, ഫോർ എക്സാമ്പിൾ ഫസ്റ്റ് ചാർജ് അണ്ടർ ആർമി ആക്ട് സെക്ഷൻ 37, that is mutiny. These are the evidence which has come. So in spite of the evidence being there on the proceedings through witnesses, the court has failed to consider those aspects. അങ്ങനെയാണെങ്കിൽ that can be pointed out and told that ഈ കോർട്ട് വീണ്ടും ഇരുന്നിട്ട് ആ എവിഡൻസ് ഒന്നും കൂടി വിലയിരുത്തണം എന്ന് എഴുതിക്കൊണ്ട് അവർക്ക് തിരിച്ചയക്കും ആ കോർട്ട്. അപ്പൊ ആ കോർട്ട് അതിനെ രണ്ടാമതും കൺസിഡർ ചെയ്തുകൊണ്ട് they either adhere to their earlier findings telling that we have considered all these things, or they say yes, we have heard, we should have, now this is our finding, so they change the findings to a different finding. That is how revision takes.
So in case there is
offense ഒന്നുകൂടെ പറയാമോ?
Offenses start from section 34 up to section 69. So the nature of offenses are like offenses against the enemy. അതായത് നമ്മളൊരു യുദ്ധത്തിന് പോകുമ്പോൾ ചെറിയ ആക്ട് ആയിരിക്കും, നമ്മൾ സാധാരണ ജീവിതത്തിൽ നോക്കുമ്പോൾ ഇതൊരു പ്രശ്നമുള്ളതും, പക്ഷെ യുദ്ധത്തിന് പോകുമ്പോൾ നമ്മൾ എനിമി ആക്ഷൻ നടന്നുകൊണ്ടിരിക്കുമ്പോൾ അവിടുന്ന് മെല്ലെ ഒഴിവായി, അതൊരു സീരിയസ് ഒഫൻസ്, ദാറ്റ് ഈസ് പണിഷബിൾ ഈവൻ വിത്ത് ഡെത്ത്. Okay, so offenses against the enemy, offenses in active service, offenses like mutiny, offenses like desertion, wherein while called for duty in an active service area you don't go, these are serious offenses. Similarly, offenses against using example, using force to a superior officer. ഞാൻ എന്റെ superior officerനെ അടിച്ചു, അതൊരു വളരെ സീരിയസ് ഒഫൻസ് ആണ് ആർമിയെ സംബന്ധിച്ചിടത്തോളം. Whereas it may not be in IPC, it may just be a use of criminal force, but no, in army, to maintain discipline, it is very much required that a senior is expected to be respected by the junior. So these such acts are viewed very seriously. E offenses കഴിഞ്ഞാൽ there may be offenses of fraud, theft, etc. also. അതുകൊണ്ട് section 52 എന്നുള്ളത് criminal breach of trust, criminal misappropriation, theft, ഇതെല്ലാം ഇതും ഉൾപ്പെടുന്നുണ്ട് അതിൽ. Falsification of documents. പിന്നെ ultimately it comes to section 69. Section 69 is, we call it the gateway to the IPC, gateway to the POCSO, gateway to Prevention of Corruption Act. Why? Because one section 69 defines civil offenses. Civil offenses എന്ന് പറഞ്ഞാൽ ഈ രാജ്യത്തിൽ വേറെ penal provisions-ലേക്ക് എങ്ങനെ കടക്കണോ അത് ഈ provision-ന്റെ support എടുത്തുകൊണ്ടാണ് കടക്കുക. For example, if a soldier commits murder of another soldier, he is charged under this section 69, but 69 read with section 302 of the IPC. Understood? So through 69, the gateway is to the IPC. Similarly, a Prevention of Corruption Act, section 7 or section 13 of PCA. So it is section 69 read with. The language used is contrary to, but actually it means read with this section. So section 69 is the last wherein civil offenses you have jurisdiction to try. Related to that, the next section, that is section 70, also says that there are certain offenses which the army cannot try. What are those offenses? 3 categories. First is murder against a civilian, that is murder against a person not subject to the Army Act. Such offenses army should not try. Again, an exception, unless it is committed in an active service area or against the enemy deployment operation ഉള്ളപ്പം ആ ഏരിയയിൽ ഇങ്ങനത്തെ offense നടത്താൻ, then you can try it. Similarly, after murder, there is culpable homicide not amounting to murder against a civilian, army should not try. And last is rape against a civilian. These 3 offenses army should not try in normal circumstances unless committed in active service. ഇതാണ് offensesന്റെ layout generally.
okay. In case of an acquittal, again appeal is what is the procedure that is it the state that files an appeal? What is the internal procedure that is to be followed? What is there any? Such a good question.
Why? Because normally there is no provision against an acquittal. As I told you, any court-martial finding requires confirmation. So if there is an acquittal by the original decision of the court-martial, the superior authority, that is the confirming authority, has an option one to send it for revision, as I told you. Even after revision, the court adheres to his earlier finding and acquits the individual. Now, under the Army Act, there is no other provision to go against the findings of the court. However, if the offense is serious enough and it is thought that retention of this individual in the organization in this background of his having committed such an offense is not desirable, then it can terminate his services by way of an administrative action. Now, this is a very, it may sound a bit controversial. Why? Because your own system has acquitted him and now you are chucking him out of the forces. But again, this has been upheld by the Honorable Supreme Court in 2-3 judgments, saying that disciplinary action is different and administrative action is different. So the administrative action is solely on the basis that such a conduct would not would make this individual not fit to be retained in the service. But otherwise, technically speaking, you can go to Armed Forces Tribunal only against an acquittal, which is next to impossible. It doesn't happen usually, though you have this legal provision of going to the Armed Forces Tribunal under Section 50. That is appeal.
Thank you. Thank you.
എക്സിക്യൂഷന് മുമ്പായിട്ട് സുപ്രീം കോടതിയെ സമീപിക്കാൻ പറ്റുമോ? അത് സുപ്രീം കോടതി കൺഫേം ചെയ്യണ്ടേ?
അത് വേണ്ട. Execution, if it is a death sentence, just as Thomas sir rightly brought out, it is a death sentence. It requires the confirmation by the central government. So that is as good as the executive authority as in the CRPC also. But when it comes to appeal against a sentence, as such, there is no confirmation required for a sentence. But appeal against a sentence obviously could be first to the Armed Forces Tribunal. Thereafter, if you want to invoke Article 226 or Article 32 or SLP against the High Court order, SLP against the High Court order under 226, then you have your legal remedies as is available to any other person of the country. But otherwise, there is no appeal, confirmation, there is no confirmation required by the High Court or the Supreme Court against a death sentence awarded by a court-martial.
So do you mean to say that the accused cannot approach the Supreme Court of India, the highest court in the land, against death as a sentence awarded by the court-martial?
Not at all. That's why I told you that he has the legal remedy as is available to any other citizen of India to approach the Supreme Court under Article 32 or under Article 136 after he approaches the High Court, or after the appeal against the order of an Armed Forces Tribunal. His first remedy is to appeal to the Armed Forces Tribunal, and if he is aggrieved by it, he can directly approach the Supreme Court. He can also approach the High Court under 226. So he has all the rights to appeal against the death sentence.
So you are allowing the accused to engage a counsel only at the court-martial level, not below that?
No, because below that there is no trial as such. Maybe you are right. There is one of the provisions of summary court-martial, that is at the commanding officer's level. There he can take assistance of the friend of the accused. We call it friend of the accused. But he also doesn't have the right of audience. Maybe because it's a very minor form of disposal. But when it comes to major forms of disposal, that is district court-martial, general court-martial, and summary general court-martial, he is entitled to a lawyer. Otherwise, not.
ചോദിക്കാത്ത ആളെന്ന് ദയവ് ചെയ്ത് മ്യൂട്ട് ചെയ്യണം കേട്ടോ, കാരണം സ്പീക്കറിനെ ഡിസ്റ്റർബ് ചെയ്യണം.
Sir, good evening to you, sir.
Good evening.
Sir, I am Lieutenant Colonel Nasir, retired. I am a practicing advocate also.
Great.
It's a refreshing, sir. You came on podium and enlightened the advocate here. Thank you so much. And sir, one clarification. You said the termination through administrative step. is it the same, the termination under displeasure by the president and the administrative step, both are one and same or different clause?
There are two types of termination. One, administrative termination I'm speaking about. One is under the pleasure of the president, because any person of the armed forces continues in service as per pleasure of the president. That is also supported by Article 310, 310 of the Constitution of India, which again says that you don't even need to give a show cause notice, etc. But usually we do follow it. And the next is termination by the central government, not by the president. That is, Section 18 is termination as per the pleasure of the president, and Section 19 of the Army Act is termination as per the termination under the powers of the central government, that is Ministry of Defense. You also have Section 20, which applies only to JCOs and that is junior commissioned officers and below, not to officers, wherein the termination could also be done by the Chief of the Army Staff. So there are three provisions under the Army Act by which administrative termination could be implemented.
Okay, sir. Sir, another query is a generic in nature. There are a lot of reforms happening in armed forces nowadays. Is there any scheme or plan afoot to reform or refine the Army Act already in existence? Because every law needs to be dynamic in nature, sir. It should get adopted to the changing social setup and all. So, is there any plan afoot?
Yeah, obviously, Law Commission has sat on that, and there are so many reports that have gone, and the things are under consideration. Because law is dynamic, it should evolve as per the times, and the steps are on at the level of the central government.
Okay. Thank you so much, sir. Jai Hind to you, sir.
Jai. Any more questions?
Yeah, one more question, sir.
Yeah.
I am Advocate Sadashivan, sir. Sir, which are the matter which can be challenged in the Armed Forces Tribunal is only related to administrative matter. No, if it is a matter related to offences, then the matter will not come to AFT. No, my question.
No, there are. I will beg to differ with you, because there are two provisions in the AFT Act. The first is Section 14, which, as you rightly say, restricts itself only to service matters. But there is a specific section, that is the very next section, which is Section 15, which deals with appeals against court-martial. And court-martial are always for offense. If you are convicted or aggrieved by the sentence awarded, then you can appeal to the AFT via Section 15 of the Armed Forces Tribunal Act.
Okay, thank you, sir. Thank you.
Hi, sir. Good evening. So first of all, I'd like to say your session was extremely wonderful and truly informative. And my question to you, sir, is, does a Judge Advocate General, have the power to dismiss a conviction order passed by District Court Martial? And if so, wouldn't that make the JAG a appellate authority?
Thank you. Good question. JAG is always advisory. His functions are always advisory in nature. He doesn't have any power whatsoever to interfere with any sentence, findings, or anything. His function is to give advice to the competent authority, the confirming authority. And as per the advice, the confirming authority also has the option not to listen to the JAG also, which usually doesn't happen, because to go against a legal advice, you should have better sort of legal justification, which normally doesn't happen. So JAG is only in the capacity of advising the superior authority to arrive at a just and proper decision. JAG doesn't have the power to dismiss anyone. He can maybe advise dismissal, but it's up to the confirming authority or the competent authority to take the decision of whether to dismiss him or not. I hope that answers your question.
All right, sir. Okay, thank you so much.
Excuse me, sir. I have a question for you. നേരത്തെ പറഞ്ഞു ഒരു ഫ്രണ്ട് ഓഫ് അക്യൂസ്ഡ് എന്ന് പറഞ്ഞൊരു കാര്യം പറഞ്ഞു. ആ ഫ്രണ്ട് ഓഫ് അക്യൂസ്ഡിനെ ചൂസ് ചെയ്യുന്ന അക്യൂസ്ഡ് തന്നെയാണോ, അല്ലെങ്കിൽ അവർക്ക് വേണ്ടി സുപ്പീരിയർ ഓഫീസേഴ്സ് കൊടുക്കുന്ന ഒരു അയാൾക്ക് ഒരു സുപ്പീരിയർ ഓഫീസറിനെ ഫ്രണ്ട് ഓഫ് അക്യൂസ്ഡ് ആയിട്ട്?
Another good question. Actually, the friend of the accused, the first choice is given to the accused himself, whether you want to name any person as your friend of the accused. The question is asked in writing. He gives a reply to it. if he has any specific name, then the organization makes all endeavors to procure that witness. It is not necessary that he will get that person, because maybe that person is deployed somewhere wherein his requirements are more than to act as a friend of the accused. In such cases, the organization will apprise him via a reply that such person, due to exigencies of service, is not available to assist you. So you may give another name, or it may itself give 2-3 options to him. These are the officers available, and from that he can choose. This is what usually happens.
അപ്പൊ superior officer friend of accused ആയിട്ട് നിയമിക്കാൻ പറ്റുമോ?
നിയമിക്കാൻ പറ്റും, യാതൊരു ബുദ്ധിമുട്ടില്ല. ഫ്രണ്ട് ഓഫ് ദി അക്യൂസ്ഡ്, ഈവൻ ഞാൻ പറഞ്ഞു ലോയേഴ്സിന്റെ സർവീസസ് എടുക്കാൻ പറ്റില്ല എന്നേ ഉള്ളൂ. If he wants, the organization can allow him that lawyer sits as a friend of the accused, but the problem is he won't have the right of audience. That is all.
Okay, so, thank you.
Yeah.
Do the officers who sit in judgment have any legal background?
That is the beauty of jury system. Any jury, I don't think have any officers with legal background, and same is the case with court martial also, that they don't require any legal background. They are laymen in that sense, but they have the wisdom of their service, of seeing the conditions of service, and he can relate to the accused under what circumstances was this offense committed, due to his huge experience sheerly by virtue of his being in the army. And as far as legal aspects are concerned, the judge advocate is always there to guide him.
Thank you, sir.
If there are no more questions, then we give the.
Sir, excuse me, sir. Brigadier Rahul, I have one question. Is evidence of act applicable in GCM, SCMs and roads?
Definitely. Indian Evidence Act is very much applicable. And in fact, section 133, if I'm not wrong, yes, 33 or 32, it itself provides that the provisions of Indian Evidence Act, as far as compatible with the Army Act and Army rules, are applicable to the proceedings under the Army Act as well, court martial. So they are very much applicable. And my experience as a judge advocate, I can vouch for it that we strictly follow the Indian Evidence Act when it comes to admissibility of evidence, primary, secondary, nature of examination, what questions to be allowed, what not to, what documents to admit, what not to. So all these, we rely heavily upon the Indian Evidence Act itself.
And sir, another one for clarification for the audience. All the convening authority as well as the confirming authority, they will be commanders in chief. I hope so.
Obviously, the convening authority is, I mean, there are rank specific depending on the rank of the accused also, as far as confirmation goes. Okay, because if it's an officer who has been sentenced to say dismissal or whatever, then it should be confirmed by the depending on the rank, by the GOC, that is a command army commander or the chief of army staff. So the confirmation obviously may be the convening or any superior authority to the convening authority. That is how it goes.
I wanted to make it clear that nobody from external branch comes in for deciding his fate.
No,
everybody
it is all,
in chain of command.
It is all within the
his brigade commander, his corps commander, then his army commander, then finally on to his chief.
Yeah, definitely. It is the channel. Army always works on the channel hierarchy.
Sir, can I?
Army, Air Force, the same Army.
I can't hear. There are so many people speaking simultaneously.
No, the same Army Act is applicable to the other wings of the force?
No. Another good question. You have a separate Air Force Act, you have a separate Naval Act.
Nice.
The provisions of Air Force Act is almost akin to Army Act. Naval Act, there are minor variations from the Army Act because of the requirements of their particular service, being in ships and the area of operation being a bit different. So they have their own independent act. In fact, all of them, even Coast Guard has its own act, BSF has its own act, Assam Rifles has its own act. So they are all different.
Sir, what happens if the member of that external force, like police, Sometimes even CRPF also get placed under command of the army for operation. In such eventuality, Army Act will be applicable or not, sir?
No, the applicability of Army Act to special persons are again dealt with under Chapter 2, if I'm not wrong. Yeah, because it deals with persons to whom provisions of Army Act could be made subject. In that category, only two forces come into play. One is Assam Rifles, and the second is Rashtriya Rifles. None other. They are not subject to the army.
Okay, sir. Thank you.
So, shall we wrap up? My
It was
request,
extremely, yeah, sorry. Please go ahead.
sorry, not over. Manoj. I request the former chairman of the seminar committee and the current enrollment committee chairman, Advocate S.K. Pramod Pallichal from Tribunal, to propose a formal vote of thanks.
Thank you, Srinath sir. Good evening, all. See, in fact, today's session, in fact, it was a very much interesting as well as informative one. Not I'm saying it's an informative one, because as we know, day-to-day functions of the court and the litigation area, we are not having much access of this Army Act and court marshalling. But the chairman has selected a variety of subject as today's session also. And in fact, our speaker was introduced the Army Act and the court-martial proceedings in a very brief manner, which will definitely help to the lawyers and the participants to address the common people also, because normally the people will ask such questions being a lawyer regarding the court-martials and other proceedings. So anyway, sir, Bar Council of Kerala, as well as the seminar committee, on behalf of the participants, in fact, Bar Council is giving a big salute to you and expressing our thanks for being with us and sharing the knowledge on, regarding the particular act. So thank you, Chairman Srinath sir, and thank you all the participants. Jai Hind.
Thank you so very much. Thank you so very much. I would like to conclude by expressing my sincere thanks to each and every one of you who participated in this, heard to me patiently, listened to me patiently, and the question answer session was extremely enjoyable. I could share whatever little I knew, and looking forward to helping you out in whatever way. Again, ending with the note that Army Act is a very fair act. We give all rights to our persons subject to the Army Act. And thank you so very much, especially being from Government Law College, Calicut, and my friend Srinath Girish having introduced me. It's a proud privilege, and thanks for everything. And all the best to each one of you. Thank you. Take care. Salute.